There you go.
Noted.
All right, well, let's go ahead and begin. Good morning and welcome to a virtual oral argument session of the 5th District Court of Appeal. I'm Judge Orfinger, and I'm joined on the panel today by Judge Cohen and Judge Eisnagel. We have 3 civil cases this morning and this afternoon. And the first one is Domino's Pizza versus the estate of Richard Wiederhold. Both sides have 20 minutes. The clock, which I hope you both can see, is set to 20 minutes and will count down backwards. It's set automatically for 5 minutes when you get into your rebuttal time, but if you want something other than that, let me know and I'll try to set it accordingly. And so with that, we'll go ahead and begin. Ms. Stein?
Yes, may it please the court, Dinah Stein on behalf of Domino's Pizza, LLC. And if I understand, Your Honor, it's automatically set for rebuttal, or because I would like to reserve some time.
Yeah, it's set for 5 minutes.
Okay, thank you, Your Honor. And with that, I'll proceed. And so starting with the main issue, this court said back in the Font versus Stanley Steamer decision, and this court's prior decision in this case in Wiederhold, that applying the traditional agency test to a franchise relationship is, quote, no easy undertaking. We submit this court exemplifies that the traditional agency control test in a franchise situation just doesn't work. To quote plaintiff's counsel.
Ms. Stein, let me ask you this. We had that issue somewhat teed up for the Supreme Court after the last opinion, and you all elected not to travel that path.
To actually clarify that, the issue that was certified was the marrying after the injury issue. The agency issue, we relied on just directed verdict motions. And I think this court came back loud and clearly and said, this is a jury issue. The jury can decide this. And by the way, it's going to be through instructions. I mean, it even, your honors dropped the footnote that said, you didn't ask for the brand maintenance instruction. So we did not go up, you're correct, on the other issue. As they say in football, you don't necessarily take points off the board when you get a reversal. But this issue is not. This issue went back for a new trial based on the closing arguments. And so we took what your honors said loud and clear and asked for the instructions that we were basing the directed verdict on the last time, which we were absolutely allowed to do. I mean, we've cited a whole section saying that law of the case.
Let me ask this. How did your instructions clarify this issue?
Because
I've been struggling with that because it doesn't seem to me, you've got disputed issues of fact here, and you had some very damaging testimony from the franchisee. And how did your instructions resolve those competing issues of fact?
Well, at the end of the day, the law is whether the franchisee, by the way, he came back into court, clarified factually. He didn't retract from his testimony, but he specifically said these are things Domino's controls, these are things it does not. Having said that, the reason the instructions are so important, and not just this case, any case involving a franchise, is that this abstract concept of control doesn't fit in with the franchise. And if you look to Domino's, and this is very important, if you look to Domino's opening statement, I mean, Ms. Zarova spoke extensively about the difference between maintaining the brand and the trademark, which Domino's has to do under the law. And
let me ask you though, the proposed instruction that you offered ended with the sentence, contractual brand maintenance and franchise support activities alone are insufficient to establish that a franchisee is an agent of the franchisor. I mean, I can't tell you, and I'm a lawyer, I can't tell you what brand maintenance and franchise support activities are. How's the jury supposed to know that if the instruction doesn't go beyond what I just read to you?
That's right. Well, the jury can know because this is not a standard car accident case. This is not a medical malpractice case. This case is about a franchise relationship and whether there's an agency relationship. The difference between brand maintenance and protecting the trademark and contractual support activities in this case was discussed at length. It was discussed again in closing. Ms. Zarova talked about maintaining the brand and the difference that Domino's has to do that under the law, and that doesn't equate to control. Joe Devereaux, the Domino's corporate representative, testified about maintaining the brand and the trademark in his testimony and how Domino's is required to maintain the brand by law, but that doesn't equate to control. It was
Well, I can tell you, I'm not unsympathetic, to this argument, but the testimony in this case, I understand that the franchisee, who Domino's apparently threatened with lawsuit, came back in and tried to clarify his earlier deposition that had been read into the record and presented to the jury. And that testimony was effectively, I think it just absolutely negated that argument. I mean, he testified that Domino's controlled everything.
Well, and I'd submit that's part of the problem with this. Again, this abstract definition of control is that nobody understands it, including this franchisee who Domino's didn't represent, who was just asked about this word control. What does Domino's control? And he equated control to the color of the pants that drivers have to wear and the advertising and things that the plaintiff tried to turn into control. Now, if plaintiff wants to say those equations.
What would you classify as control? At what point in your mind does Domino's control the day-to-day activities?
Well, depending on what test, and we advocated for the instrumentality test, and we asked for an instruction that says if Domino's controlled the actual instrumentality that caused the damages at issue.
The car. They have to control the car. Is that,
Give me the facts. Yeah, give us the facts.
Facts would be hiring drivers, having a say in who drives, being able to schedule drivers, in fact, just as examples, the cases we've cited, and we've cited to numerous jurisdictions, which most have said these brand maintenance activities do not equate to control, where they have found a jury issue is, for instance, there's a McDonald's case and a Burger King case where someone bit into something and they said, well, McDonald's and Burger King have enough control over food preparation that it's a jury issue. And so we've actually haven't taken a position on this appeal that it wasn't a jury issue, but the jury has to decide whether Domino's had enough participation in drivers and scheduling drivers in how they drive in the day-to-day operations of the store, as opposed to just setting standards.
But you also recognize that no Florida court has adopted that test.
We absolutely have, and that's why we've teed it up in the brief as we did. We told the court that outright. She stated she didn't want to go beyond what she thought a trial judge should do. We have advocated for the instrumentality test that dozens of, or at least I believe 20 jurisdictions that we cited have adopted. But I'm going to go back to just we're talking about the testimony of Mr. Fischler, the evidence in this case. If we look to the closing argument, the plaintiff was able to define and control what constitutes the agency relationship and control. And that's really the problem, is that he actually argued that, and he was the one who said Domino's arguments made no sense, because as long as the franchisee and Domino's are both in the business of making and delivering pizza, that's a relationship, an agency relationship, and that's control. And we've proven it by, he said, clear and convincing evidence. That's not the test. We've cited to numerous other jurisdictions with these identical, or at least analogous facts that many of them have at least have either directed a verdict for the franchisor or said it's a jury issue. But by not having the instructions, that the plaintiff was able to come into closing argument and say, it's the test I tell you. It's that as long as they're both making and delivering pizza, that's control. And by the way, Domino's is going to argue that brand maintenance and protecting your trademark doesn't count as control. And he said, that's not the law. Well, we take issue with that. That absolutely is the law. The judge precluded Domino's from talking about anything that wasn't in a jury instruction in closing. And so, whether this court believes that the plaintiffs had a good case or not doesn't address the issue of what constitutes control, what the jury should be looking at. And that's really the issue here, because if you look back to the Font case, Judge Sharp did what we did. She and the panel looked to other decisions in other jurisdictions to try to get some guidance of what constitutes control in the franchisee relationship.
Counsel, isn't your best argument that the instrumentality test should apply? Is that your best argument?
That is the argument we would prefer. That I think is the strongest argument. That is
that's my question. So
yes.
So you think, but I mean, you essentially concede in your brief that we would need to go en banc to do that.
Yeah, and I don't know if we were overly cautious in the brief. I don't think this court has come out and actually rejected the instrumentality test. We raised it in the last appeal. The court didn't comment on it. So I don't know. We were being cautious.
That's what you asked
Right.
for in your brief. You said, we want, essentially you said we want the court to go en banc and adopt the instrumentality test, correct?
Or to certify. That's correct, to the Supreme Court, because no court has adopted it in Do you think your argument on directed verdict at page 46 of your brief, do you think that's sufficiently briefed for us to even take that up? It's 2 sentences. Right. Well, we've cited it to the record. The record was made, and we've cited to the rule that precludes us from moving for a panel hearing, a full panel en banc hearing in a brief. So, but again, we did seek the instruction. We did make this record below, certainly, and plaintiff hasn't stated anything to the contrary. Having said that, we're sticking with the Florida law. I mean, we have a robust law from Florida talking about day-to-day operations and brand maintenance. And this panel, if we were to just continue with Florida law, absolutely, I think can and should recognize that the instructions are insufficient. Having said that, I do want to, just looking at the time, talk a little bit about damages. And we've raised these issues, some of them the last time, but they weren't addressed in the opinion.
The fact that 2 juries ended up really fairly close in terms of damages impact your argument that the damages awarded were excessive?
No, because we've raised the same issue, and that is that this became a case about, first of all, this became a case about Mr. Wiederhold. And just to talk a little bit about the photographs and the please kill me statements, this has always been our position that, first of all, Domino's never even attempted or wanted to take issue with Mr. Wiederhold's injuries. I mean, that just was not at issue. Domino's never challenged his catastrophic condition after the accident. There wasn't even cross-examination on his condition after the accident. So number one, we had 3 witnesses testifying about Mr. Wiederhold's condition in this case, and there's no question it was catastrophic. The photos were not there to address any issue in dispute, which is the law regarding photographs. We contend and have contended that they were put in evidence to get a visceral reaction from the jury and were absolutely unnecessary. And I submit, for instance, there's the picture of Mr. Wiederhold. And by the way, these photographs were taken for his personal injury case by the physiatrist. But there's a picture where he's staring into the camera with a trach tube. I mean, it's a horrible picture. It has no relevance to Mrs. Wiederhold's damages, which, again, 3 witnesses, different witnesses, some of them overlapping, testified about her damages and how this impacted her. So what the photographs added to this was absolutely nothing other than, as was argued below, making this about as much Mr. Wiederhold's injuries as hers. And the jury respectfully cannot, it's very difficult for them to separate the two. Same with the "please kill me" statements. Again, this is it's a graphic statement. We know how devastating the injury was to Mr. Wiederhold, and we did not take issue with how much care Mrs. Wiederhold gave to Mr. Wiederhold. But to put that in front of the jury, again, is just to induce a visceral response. The other argument we've brought forward, and we continue to say, is that we have to look at damages awards in a context of what's generally awarded. That's been a proper test that's been recognized by the appellate courts of looking at similar verdicts. We can't find, and in fact, the plaintiffs haven't found any verdict where someone obviously can't find anything where they married the person after the injury, but also where they were married for 9 months at the time of the death. And we've looked to that the best comparisons are the tobacco award cases. We have a lot of verdict or several cases that talk about verdicts in the $10 million range, $11 million range, where the appellate courts struggle with those verdicts there. And what they always go back to.
That in the context of punitive damages, though, those tobacco cases?
The tobacco cases, well, we've only looked at compensatory awards to compare with this. We've stayed away from punitives. Part of the problem is that a lot of the tobacco cases have that punitive element, which tends to inflate the compensatory damages, but we've only compared compensatory damages and nothing's even close. I mean, even in the context of compensatory damages, when these appellate courts have looked at the tobacco awards and struggled with those, they've always looked back to the plaintiff, the survivor, having married the decedent a long time earlier. They all involve long illnesses and care for the decedent. And they always go back to the fact that these were 30-year, 28-year, 38-year marriages. There's just no comparison here. And I submit that it was the visceral, the photographs, hearing about Mr. Wiederhold and turning this into as much about his injuries as hers that caused the jury twice to give these kinds of awards. Now, I'm going to ask for clarification. Is the clock my rebuttal time, or is?
Yes.
Do it.
Yes,
Yes.
that's my rebuttal. Thank you, Your Honors. Then I will save the rest of my time for rebuttal. Thank you.
All right, thank you. All right, Mr. Mills?
Thank you. Good morning, and may it please the court. John Mills on behalf of Yvonne Wiederhold. I think that the court has the instruction issue pretty well under control here. The summary I would just say is that the instructions that they proposed would have created more confusion, not less. The day-to-day activities, that's already encompassed in the standard instruction, particularly when you look at the distinction between independent contractors, where it says that's not supervision of how the work is done. And how the work is done, there's lots of different formulations in the case law other than day-to-day activities. Certainly the parties agreed here, and both of their arguments were that day-to-day activities was the test.
Well, but didn't the plaintiff really flip-flop at the last minute on that instruction?
No, not really. What the plaintiff's position was was that we can have the day-to-day and we'll go with that if they wanted. But if they want to start adding a bunch of other stuff to the standard instruction, we're just going to stick with the standard. Because once you start doing one special, well, then you need another special and then another. And we didn't want an agreement to add day-to-day to start down that slope. We said, fine, let's just go with the instruction we had the last time. They raised 10 issues the last time. They didn't even challenge the jury instruction. So this seemed to be the safest thing rather than going in and trying to tinker with the standard instruction.
What was the instruction that you all proposed and then withdrew?
It's just one sentence. We took a sentence out. We had in there the same sentence they asked for. We had in there about day-to-day, it's control over day-to-day operations. And that's not the standard.
So what was the problem with that?
Because it's already covered by the standard, so it's not necessary. And the only reason we objected to it is because we don't want to start, once you start tinkering and opening the door, then they want more and more.
But
And
you
that was
know,
our agreement.
at the beginning of the trial, you agreed for that instruction to be given.
No, we didn't.
And then, pardon me?
No, we did not. We did
Well, you
not.
submitted it.
We submitted it saying there was no agreement. Our submission says the parties have not agreed to it. This
Well,
is
but
our
you
sub-
agreed to it. You were offering it.
That's right. And they didn't offer it. They had a different instruction that didn't have it in there. Okay. And what the agreement that's not even on the record, there is no agreement that's enforceable that's on the record. But all that was said was, if you want to stick with this, we'll go with this. If you want to start adding other stuff, we're going to stick with the standard. And that's what we did. And the standard fully covers this. Both sides argued day-to-day. The dispute was over day-to-day. What does that mean? Domino's said day-to-day means just your minutia of personnel and bookkeeping decisions. And we said, no, it doesn't. It means the day-to-day operations of the franchise. What does the franchise do? It makes and delivers pizza. And that's where the control is. And it's on every aspect of operation.
Counsel, how does Domino's protect its brand if it doesn't have some basic rules for the preparation of its product and uniforms, opening hours, things of that nature?
Sure. Well, I don't know about opening hours, but certainly uniforms, logos, all the things that go with the brand. The law, I think, is correct. I think they're correct that if that's all you have, that wouldn't be sufficient. And we certainly have that.
What about food preparation, opening hours, closing hours, things of that nature?
I think you're now going beyond what's necessary to protect the brand. When they
There's
say,
no need to protect. Oh, hold on, counsel. There's no need to make sure that the pizza is the same across various stores.
if you're trying to control everything to make it appear that it is the same as a Domino's store versus a franchise, that is respectfully the kind of control that they are your agent.
Counsel, is that argument, that argument seems to me pretty broad. It seems to me that every single franchise type operation as they exist today would fall within that definition.
I certainly don't think so at all.
Give me a couple
Just
examples
limiting it
then,
to
because
how you make the
every franchise operation that I'm familiar with not only controls name tags and uniforms, but also says, hey, here's the basic standards for our product, whatever that product might be.
That's not what I'm sorry. I don't mean to be disagreeing with you on that. I agree with you completely. They do more than that. This is more than just use this recipe. And it's more than just how you make the pizza. It's how you run the business. It's every aspect of how you run the business.
Well, don't say general things. Give us specifics, right? You're in the, you prevail below that you presented evidence. What evidence was more than just sort of the basic, the baseline, right, for prepping food and things of that nature?
Thank you for redirecting that me, because I think that is very important here. And it would even go to the instrumentality test if that applied. Their own witnesses agreed that many of these standards were for driver safety and the safety of delivering pizza. They had specific requirements on how you could hire a driver. You had to do specific background checks. You have to check their driving history periodically. You have to inspect their vehicle. They can't have other people in the car with them. They can't be on their cell phone. They can't have a weapon with them in the car. There's all kinds of things that are not just suggested standards that would be a business format of, hey, here's something you could use. These are things they were audited on, And they,
Oh, no,
their
I mean,
own
those
witnesses
all,
agreed.
why aren't those all just sort of minimum requirements to protect the brand? I mean, I assume Domino's doesn't want drivers out there with big Domino's logos on their cars, you know, blatantly breaking the law and driving dangerously and things. That would hurt their brand, right?
So that's where we get to. There is no case in Florida or across the country that says if the intent of having complete control of the franchisor is just to ensure your brand, that that's a defense. It's not an intent-based defense. It just says if it's the minimum control necessary for brand maintenance, then that's okay. We have way beyond that. When you're controlling the background checks of the drivers, the inspections of their vehicles, making sure their driver record, I think they have to check it every 6 months. Those are things for safety. And when you're controlling at that level of detail, it's really no different than if you were owning the store yourself.
What about
And
the
you should
safety
have
of the food? I
liability.
mean, should Domino's be able to have base minimum standards to make sure that their pizzas are safe to eat?
Yes.
That's a safety issue, right?
Well, I don't know about safe, that it tastes and looks the same. If they're getting to
Well,
safety, that's not
So
about.
you're
brand.
you're
That's-
suggesting that Domino's can have brand requirements that say, well, the food needs to look good and needs to taste good, but Domino's can't care if it's safe.
I think they can care if it's safe. My point is that the control test, there's no law in Florida that says it's an intent-based test. Instead, it's a test of what is the actual control that they had or they could have had under their documents. It doesn't, you don't look at intent. The test
So
is it
so
only
is
the
it
minimum-
control over who drives, when they drive, and what routes they take? Or is it control over, hey, they need to have a license, you know, they need to have a safe driving record, they need to be insured, things like that? Which one is it?
I think it's both, maybe more of the latter. And the latter is sufficient for a jury. These are still jury questions. We're not saying we get a directed verdict, although I think we would be entitled to one. But what we're saying is that these are controls. It would be one thing if they said, here are guidelines, we suggest you do them. This is how successful franchises do things, you ought to do them. And if they left it at that, maybe that we wouldn't have such a strong case here. But these are not just guidelines. These are not just suggestions. These are mandatory requirements for which they can lose their franchise. They get audited. And if they're not doing these things, Domino's has the ultimate control. It can terminate them. When they come up with, here's another aspect of this case that takes it out of brand. The franchise agreement says that if a franchise comes up with a new method of business or a new idea, that is the intellectual property of Domino's, not of the franchisee. They are controlling every aspect of how they operate their business. Yes, they give them the discretion to decide when you fire a driver.
It sounds to me like that's not control at all. That's saying, hey, if you go out there and do something we don't even know about and it's great, you need to tell us so we can have it. That doesn't sound like control to me.
Sure. Judge Eisenhagel, I think we just disagree on the test, and I would respectfully say that your arguments here would be a matter for the en banc court, because this
Right.
was
Isn't your
decided.
counsel, isn't your best argument that this court's already decided this issue?
I think it's the strongest argument because we don't have to address the merits, but I feel our merits argument are very strong. And I would respectfully suggest that your questions of the test are going well beyond what Florida law is. And that might be a good reason for the legislature to consider changing franchise law. And certainly Domino's can go ask for a change in the law, but normally we do that through the legislature, not
Would
through
it need
the
to be a
judicial
change to the franchise law, council? Is that where they'd need to change it? I'm not sure that's right.
I think they need to change the Florida statutes to, I don't know what chapter they might want to put it in, and I'm not going to draft it for them, but it would be a difference in the law right now. And if there are reasons, if we want franchises to be able to control everything and not be liable if they say it's for brand, that's a policy judgment that the legislature needs to make, not this court, respectfully. And again, the jury instruction, this is really just about a jury instruction, respectfully. The issue that's really that this panel has discretion to review on is about a jury instruction. And the jury instruction doesn't help answer these questions. In fact, the jury instruction they proposed raises these questions. This debate that you and I are having, Judge Eisenhagel, would be something that the parties below would have argued over in closing argument. And the jury would have had no basis to reach a conclusion as to which is correct. And so this this extra instruction that they're asking for would have been ambiguous and would have caused more trouble than it would have saved.
You know, I go back, I'm still concerned about how you all propose an instruction and then pull the rug out at the, you know, at the last minute, and then argue that the only law that you're going to hear is that from the judge, and you're not going to hear anything about A, B, and C, and D, and E. You know, I think that that's troubling to me.
Well, Your Honor, I'm having a little bit of trouble understanding why you think we had agreed to it. We filed a notice that said we had not agreed to
You
it.
submitted it.
We did submit it, but it wasn't what was read to the jury at the beginning of the trial was the same thing that was read at the end. When we had the opening statements, the judge had already read an instruction, which is, we just said, let's stick with that at the end. We said with the standard, we said we can talk about whether we do specials at the end. And the reason that we changed was because things changed during the trial. Not only did they propose this new instruction that we said our agreement was, if you just stick with this being the only change, we'll agree to it. But not only that,
They didn't
they
propose that
changed the
until you,
testimony. Yes,
they didn't propose that until you withdrew your proposed instruction.
correct. That's correct. That is
So
correct.
we don't know what would have happened if you would have just left it with your proposed instruction, the day-to-day control issue.
Well, I think if we would have left it in there and agreed, it would have been read to the jury and it wouldn't have changed anything because the parties argued that standard. There's no reason, there's no basis in this record to find that the jury was confused by that.
Well, but they might have argued it, except then, you all got up and said the only laws on this topic is what the judge is going to instruct you, and you're not going to hear anything about that.
I think that was about brand maintenance, Your Honor. That's not about the day-to-day. We said day-to-day is the test, and we said it's the day-to-day of making and delivering pizza, not of running your books. So that's where the issue went to. And one of the main reasons if you look at the record, when we changed this is because they changed things. We had a prior trial and Mr. Fischler testified by video deposition. We played that again. It was the same testimony. And in that testimony, he agreed that they had control over day-to-day operations. He expressly agreed to that. When they told us now they're going to call him as a live witness, well, that tells us they've got him ready to change his testimony, which is what happened. And he's going to change the verbiage and he's not going to say that. And now we're going to be in a trap that we put in a jury instruction, some specific language that he's denying. And when they change the game, we can change things too. And I'm not aware of any law that says that you can't change your proposed instruction before the charge conference. And that's all that happened here. We had a charge conference, and by the time of the charge conference, we had taken that out and there were arguments. And the trial judge, I think, was very solicitous of them to make sure there wasn't prejudice. Said, oh, I see they've changed their position on it. You take as much time as you need. Tell me why you're prejudiced. You can do it tomorrow. We can come back and discuss this tomorrow. And they came back after the break and said, no, we're ready today. We're ready to go. And we had a charge conference about it. If there was error in not doing this, if there was anything improper of not giving that sentence, that clearly didn't have any impact. The issue here is whether the jury should have been given the instruction that you have to have more than brand maintenance activities. That's what we really objected to. And we don't want to die a death of 1,000 cuts by starting to change things. And, that instruction, by the way, has been answered by this court. That wasn't an issue for the jury. The instruction was you have to have more than just that. And this court held we had more than just that in the prior appeal. So if the jury had been read that instruction, we would have been entitled to an instruction right after that. And the court has determined that they've provided more evidence than that. It really wouldn't have helped the jury. The decision for the jury here was just, is the level of control that these documents and this testimony show sufficient control under the standard jury instruction? And the tests they've proposed don't change that. In fact, this brand maintenance, they admit in their brief, they wanted it there so that they could tell the jury not to place undue weight on brand maintenance. But jury instructions aren't supposed to tell the jury about how much weight to give evidence. They're not supposed to provide that foray. They're supposed to provide the legal framework for the advocates to make their arguments. And that's all that happened in this case. And once you start going down that line of giving specials, we would have been entitled to a whole host of specials from this court's opinion before to tell the jury, I'm sorry, that the labels don't control. This court said that. There's cases we could have asked for an instruction that says just because they label them independent contractors in the agreement, that doesn't control. These are the kinds of instructions that are supported by the law. There's law that says that, but when you start instructing the jury, you're commenting on the evidence. And we provided pages 20 to 24 of our answer brief, all the reasons stated in case law by the Supreme Court and the Standard Jury Instruction Committee about the theory of instructing juries and why we are not supposed to give these kind of instructions. They haven't had anything responsive to that in their brief or today. Again, on the instrumentality test, if that applied, we meet that too. I mean, that I think is an alternative basis. Certainly if you're controlling the instrument that causes the accident, and here when they control who can be a driver, when they can be a driver, how they can be a driver, what kind of car they can have, what kind of inspection the car has to pass, all these things, I would submit that that at least creates a jury.
What I struggle with is why aren't those the minimum sort of requirements, right? I mean, there's a difference between controlling something and saying, hey, but the car needs to not explode on the highway. The driver needs to have a license, you know? So where's that line? If that's the test, where's the line?
I think each person would draw that line differently. I think you would draw it differently from me, but it's a jury question. And at the end of the day, it's a question.
So if the only evidence at trial was Domino's requires the driver to have a driver's license, that would be a jury question?
If that was the only thing.
That's correct. That'd be a jury question?
No, that by itself, if
You're
they
controlling the
control over
driver?
Anything else? No, that would.
Counsel, you're controlling the driver, right? You're saying, hey, they have to have a license.
Yeah, I don't think that by itself, if they had no control over anything else, that probably.
But now it sounds like a slippery slope, right? So it's not, that's.
Line drawing problem, and the jury is who draws the line.
So why can't the jury draw the line at, hey, they need to have a license? That's enough control.
I think that because I don't think that's very much control. You're asking me, John Mills, as a juror, I would say.
I'm asking you, is that the jury's decision or is that a question of substantial competent evidence that can be reviewed de novo?
Listen, I would have to concede. If they didn't have control over anything else and that was all that we had in this case, that by itself isn't sufficient. I'm not sure where the line draws.
What do you say about the $8 million? What do you say? Was the $8 million award excessive? What's our standard of review?
It is abuse of discretion, and it's doubly deferential to the jury. You defer to the trial court. The trial court had to defer to the jury, but exercise also his independent judgment as a seventh juror to make sure that it doesn't go beyond the bounds of the law. And here we had not just one jury of 6 people, we've had 2 juries of 6 people. We've had 12 members of the community hear this evidence on damages, and we've had 2 learned trial judges review that, who sat through the hearing, saw all this evidence, saw this testimony, and determined that that was not unreasonable. And this court should not second guess all of those people. This award is well within the range in the Engle tobacco cases, and my sister is correct. Those are just the compensatory awards, not the punitive damage awards. And courts have approved $12.5 million. We asked for $12 million here, and we were only given $8 million. Now, it was a shorter marriage.
Terrible length of marriages in any of those cases?
I don't think the length of marriage is comparable, but you have other facts here that make up for it. I've done 30 Engle cases. I've never seen a case where the surviving spouse was asked by the decedent to kill him, to end his life because he was suffering.
All right, counsel, you've exhausted your time.
If I may just, one fact to end, please.
Go ahead.
This is an unusual case because post-traumatic stress disorder. We have an ongoing diagnosis and treatment going into the future here. I'm not aware of an Engle case that involves such a specific fact.
All right. And Ms. Stein, I'll give you an extra 30 seconds as well.
Thank you, Your Honor. The day-to-day instruction absolutely was agreed to in the beginning. It was submitted by the plaintiff. And in fact, and this is stated on the record, Ms. Zarova's opening statement hammered on day-to-day operations in reliance of that. So there's no question on this record that it was agreed to in the beginning, and then plaintiff, they didn't give much of a
Counsel, I think your
explanation.
bigger problem is, I struggle with, how does your proposed instruction really narrow it down how does it help the jury? I mean, I still struggle even with your instruction to identify exactly where that line is. Can you identify it for me clearly?
It's a difficult line. I think, and we just for context, and when we went before this court in the first appeal, we argued exactly the colloquy that Your Honor had of none of this rises to the level of anything other than brand maintenance, and it became a jury issue. The problem, and I think the colloquy really exemplifies this, is that if it's going to go to a jury, what is the definition of control? We're not talking indicia. We're not talking about what's in the contract. We're defining and limiting control to the jury in the context of a franchise relationship. So if
But
a
did
court,
jury instruction have that same problem? You're arguing that the definition of control wasn't sufficiently informative, but how is your definition of brand maintenance and contractual support any more informative?
because that tells the jury, and it allows counsel to argue that when plaintiff talks about the color of the pants and the taste of the pizza, which are brand maintenance activities that were discussed in the trial, that's not equal to control. That counsel can argue based on the instruction. We purposely kept it very brief and from the case law so that it wouldn't turn into something more argumentative, but counsel's very capable of arguing that when it is in evidence. And again, if you look to the opening, the closing, and Joe Devereaux's testimony, they specifically talked about maintenance of the brand. And that's really the issue is plaintiff, we've heard now counsel saying anything is control. They can get up in closing now and say any of this is control, and there's absolutely no guidance for the jury or a way for defense counsel to take issue with that in response and say, no, not all of this is control. We've stuck with the law from the other jurisdictions, which have followed this court's law, which is brand maintenance and lack of day-to-day control alone are not an agency relationship.
All right, counsel, you've exhausted your time. Thank you so
Thank you.
much to both of you.
Thank you.
Thank you.
Judges Cohen and Eisnagel, do you all have the telephone call-in information for our conference call?
Not handy.
Oh, I'm so disappointed in you, Judge.
It's not the first time.
I'll email it to you in just a
Okay.
minute. All right,
Great.
thank you both. Thank you all. Bye.
Thank you.